He was arraigned on March 2nd. I'm now sitting here a month later and no discovery's been picked up. Nobody's working on his case. Counsel, that's not how law is practiced. You all right?
Floor's uneven right now.
For calls the case of people versus Corey Jones. Basis.
Good
afternoon, Your Honor. Edward Lucas on behalf of Corey Jones in 1318.
Good afternoon, Judge James Murray, P 5490, appearing on behalf of Mr. Jones on the subsequent matter.
All right, what are we doing?
Now, today,
Your motion.
great. This is the time for my motion to withdraw. First of all, I want to apologize for inconvenience of court. If so, I talked to mom. Well, actually, I was in contact with Mr. Jones's mother for a matter that brother counsel is on now. They were saying me on such matter. In the middle of negotiations for such case, he was arraigned on this new matter. In the rush and the haste of attempting to get off that case to make sure the arraignment went successful, failed to put limited on my appearance for the arraignment purposes. And after discussions with mom, she had decided to go in a different direction. So with that being said, I would ask that my motion.
No, but your motion says that the relationship between you and Mr. Jones broke down.
Correct.
Okay, but that's not what you just told me.
So to flesh it out more, I was speaking to Mr. Jones on behalf of his mother. His mother was the one who went through everything. His mother reached out to me. His mother kind of did all the contacts. Mr. Jones has been incarcerated in Washington so far.
I know, but I'm trying to figure out what's the basis of your motion to withdraw.
The basis of the motion is that I was engaged by Mr. Jones's mother prior to the arraignment. Was never what I actually. She does not want to proceed with me as counsel.
Why didn't you say that in the motion? I guess because all this has done is delay Mr. Jones's matter. I just
understood, Your Honor. I do apologize for the inconvenience.
Well, it's not just apologizing to me, it's Mr. Jones. I mean, I'm trying to he's got a right to have his matter proceed forth, and now Mr. Jones, what do you want me to do? You know? My Lord. Yeah. Grab that motion. Yes, Senator.
Yes.
Mr. Jerkins, in your matter, what are you doing?
Your Honor, I sort of the tail, the other case is sort of controlling. I'd be asking for an adjournment to follow that case. My case is a fleeing matter. The other matter.
I'm sorry.
Is that just a fleeing case?
Yeah, but you don't have to take the baby out. That's what you're trying to do. I like hearing babies more than I do attorney. You're all right. Okay. Thank you though for having that consideration. You're good.
And I believe it's a 15-year max on one of the felonies in the other matter. So I think that I don't have that report. I don't know much about it at this time.
Has the discovery been sent? I mean, where is his case at this point?
I have not received discovery on this matter.
Pardon?
I have not received discovery on this matter.
While in our office, I do have the discovery in our file media. But I'm not sure.
He was arraigned on March 2nd. And so nobody's been working on his case since?
The arraignment for, let me just clarify, for the case ending in.
The one you entered an appearance on. He was arraigned on March 2nd. I'm now sitting here a month later and no discovery's been picked up. Nobody's working on his case. Counsel, that's not how law is practiced. Ever. And certainly not here in Washington County. If you were going to withdraw, then you go ahead and you get the evidence. At least then when new counsel steps in, you can turn it over to them. But you don't do this way. You don't do this to Mr. Jones. Have you ever talked to Mr. Jones?
Not directly.
Then why did you lie in your motion?
When I spoke to his mother, she indicated she
Do
represents.
you have a copy of your motion? Look at paragraph 2.
Okay, I'm here.
Read it out loud. What does it say?
It states that there's been a breakdown of communication between Attorney James Murray and
How is there going to be a breakdown if you never talked to him?
Your Honor, from my perspective, I was speaking to his mother. Expressed Mr. Jones's wishes. I should have outlined that in my motion after discussing that.
Meaning you should have told the truth and had full candor to the court is what you should have had.
I'm explaining exactly what happened right now on the record. I was never attempting to mislead the court. I was speaking to.
No, you did mislead this court. You are making me, when I look at this motion, it appears that what has gone on is you and Mr. Jones are having communication, and for whatever reason, there becomes this irreconcilable thing between the two of you where you can't represent him. That's not it.
If I could put a
You
minute,
never talked to him. And now he's a month out from the time that he's arraigned, and you never talked to him. You shouldn't practice criminal defense anywhere. Because your primary obligation is to your client, not his family, to him. Mr. Jones, what do you want me to do? It's your case, it's your life. What do you want me to do?
What do you mean? Like, as far as what?
An attorney. I know you got Mr. Drukas on that one, but do you want him representing you? For you, Mr. Jones, I'm going to grant the motion to allow him to withdraw because he hasn't done a darn thing for you. Don't come back into this county until you're ready to practice like you should practice. Goodbye. Goodbye. I dare you to slam that door. Okay. I'm good. Miss Gaines, on this case, I think he stepped in or did whatever he did, but I don't think the PD was ever appointed. And I don't know. I mean, I want to get his case moving along because if
the public defenders is appointed, we can get that discovery over to them. So it was such an appearance for everyone. Get that over to them public stairs tomorrow. That would be hard to document, police court, media, not one or all the files.
all in, okay. And
We could
the
adjourn
only
when
thing
we,
that I'm worried about is you're on this other case
I'm on the other,
because of a conflict with the PD,
correct.
right? I'm just trying to make sure, is there going to be the same conflict? Because then we can try to skip that step. I mean, it sounds crazy, but skip that step to get somebody appointed that's going to represent him and talk to him about the case he's on.
Let me see if I can shepherd you.
Okay.
Cool, you go.
Oh, bring the baby back. See, that's upset. It took the only person I liked in the courtroom out. What, are you worried that she's talking too loud? Are you? Don't really, I'm serious. Don't worry about it. If she's got something to say, well, I'm going to let her say it and we'll just all wait.
Nicolette.
All right, Mr. Jones. Okay.
Are they down in the back office? Because I think if they have a conflict, they have to figure out some way to do that and then get.
Typically comes.
Right, yeah, exactly, but I think what I need to do is appoint the PD first, then get the order withdrawal and appointing you, since I don't do the appointment, but. Okay, tell them, are they hearing it? They probably, I don't have them on.
No, they're not.
Can you let them know that on Mr. Jones' case that and tell them which one it is, and that Mr. Drukas has his other case. And we're not sure whether the PD has a conflict. Mr. Jones, I apologize to you. This is not the way it's supposed to happen, but I didn't do it, but we're going to try to make it as right as we can. All right. I can see. I can see that.
Based on Mr. Gaddy's look, I think we will likely have a conflict on this matter.
On this one.
Yes.
Okay, then the approval chain to appoint counsel for him. Can you do that, Ms. Gaines? Can do that? Okay, so here's what I'm gonna do. This is gonna sound really weird. But I'm going to appoint the public defender. The public defender will then have a conflict. I then need an order from the MAC office.
I can,
And maybe I don't have to wait for the paperwork. Can you ask them that if the PD has a conflict, which it looks like they do, they'll get that. Will they be appointing Mr. Drukas? Because then I can proceed with this matter and we can go and we'll just follow up on the paperwork.
Mr. Drews, wanting to make sure that discovery gets to them tomorrow.
I'd ask for the week adjournment so I can review discovery if it does come to
See
me,
where-
and then we can come.
And I just can't appoint you myself.
Yeah.
And so I have to wait from a verification from them that that's what they're gonna do.
Yes.
To who? She doesn't have an answer yet. She should have an answer already. Type in this. Judge wants to know what's taking so long. Well, I think here's what I do. Since it's a PD case at this point, I'm just going to adjourn both cases out to the 9th. We'll just make sure to follow up today with all of the paperwork. Okay, on that. So I'll adjourn both cases, probable cause conference, April 9th, 2026, 9 a.m. Bond will continue in both cases. All right. Mr. Jones, you understand kind of what's going on?
Yeah.
Got it. So one of two things will happen. It's likely that there's a conflict there, and so that you'll have Mr. Drukas in both of your cases. Okay. If not, worst case scenario, you'll have Mr. Drukas, you'll have the public defender on your case. But you got an attorney that's going to represent you. Okay. All right. We'll see you next week.
But the council was wanting to send the appearance to us, so we know who to send it to tomorrow.
Right. Okay. They'll make sure. All right. Thank you.
Thank you, Your Honor.
That's it. So do you want to go to jail? I mean, because we can just cut to the chase. I can just send you down. Courthouse case, People versus Aaron Bucko.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Bucko, who stands to my right. Attorney for the record, sir.
Aaron Bucko.
Thank you, Your Honor. I am ready to address the warrant and the progress report if the court would like to hear about that first.
Yes, they would.
Thank you, Your Honor. As the court is aware, there was a progress report sent out. It was around Christmas, I believe it was the 23rd of December, that there had been some missed and late blows into the sober link. And at that time, there was a warrant issued. At that time, I did discuss it with Mr. Bucko.
Go ahead.
Oh, sorry, Your Honor. And at that time, I, of course, discussed the importance with Mr. Bucko of blowing on time. He stated to me at that time, of course, he stayed in constant contact with me throughout this case. He stated at that time that he has not consumed alcohol. He does take this matter very seriously, and largely due to those late or missed tests has to do with work. He does have full-time employment. He works in a warehouse. He usually works from 6 in the morning to 5:30 in the evening. He states to me, he works this schedule Monday through Friday. Once in a while, he'll even start a little early, working at 5 a.m. Again, he does this Monday through Friday, full time. He works at a replenishment, so often sometimes he misses the sober link blows or they come late. I did receive also a letter or an
He's
email.
got a 3-hour window, so he's up for 3 hours.
Are you up for 3 hours at a time, Mr. Bucko?
Could be, it's different every time.
And
Go ahead.
I did discuss that with him and asking about if we could request the court to switch to a scram tether. He is asking at this time if the court would consider recalling the warrant and putting him on a scram tether. He did complete an alcohol screening and assessment through Ron Schwartz, which I just received yesterday afternoon and provided to Mr. Siller yesterday afternoon. That being said, there is a potential resolution in the works. So I guess I'll comment further on that in a little bit. But I also received a letter in support via email from his mother, who one of the quotes in the letter was that she's not a mother who says that her child will do no wrong, but she did want to say that although she acknowledged this was a serious charge, but acknowledged that Mr. Bucko did take this seriously. And to her knowledge, she does not believe him to be drinking and does believe that a lot of this was due to the scheduling and the blows. I believe that Mr. Bucko will be able to show the court that he is abstaining from alcohol and is taking this matter seriously if he is able to be placed on a scram tether so that he can show that he has not been drinking. I do acknowledge as well that since that warrant was issued in end of December, that there was only one, based on the progress report I just received the other day, there was one further late blow. It appears that it was a 37-minute late blow. I'm not.
Yeah, but that is not, does not paint an accurate picture. Because what we had was, he had numerous late blows prior to the time prior to December 8th. We didn't just issue the warrant on him. We sent an order telling him he needs to comply with it, or the court was going to have to take further action.
That is, yes, Your Honor. Yes, Your Honor.
So,
and
go ahead.
Oh, sorry, Your Honor. And I did remind Mr. Bucko of that. And frankly, there is no getting around the fact that he did blow late and that was a court order to blow within those time windows. And I got kind of serious with him and told him that he needs to comply and that there was that second chance given with the order to comply previously. Then there was the additional progress report that was submitted the end of December. Then the warrant. Since then, there has only been one late blow. Mr. Bucko does maintain he has abstained from alcohol. I'm not in receipt of any reports that he did test positive at any time for alcohol. Quite frankly, I'm asking if the court would give him yet another chance and put him on a scram tether so that we alleviate the whole window time. If he has any sip of alcohol at any time, day or night, of course, it would register. That would be immediate bond violation, and he'd know exactly where he would go immediately. He is asking for the court to give him another chance. He again maintains he's been staying abstinent, and it is our intention for him to hopefully start AA soon so that he can take advantage of a potential offer in the works. To that end, Your Honor, as to the pretrial, we were going to be requesting a brief adjournment. But as to the warrant, Your Honor, I'm respectfully requesting if the court would consider canceling the warrant.
You've said it like 8 times. I get what you're asking. Anything from the people?
Oh, and it's the court's discretion, Your Honor. The late testing is obviously excessive.
Yes. all of these couldn't have been related to work, could they?
I'm assuming that, yeah, they probably were.
So let me ask you this. There's a 3-hour window. Why aren't you blowing at the beginning of that 3-hour window?
I try to, whenever like in between those 3 hours, I try to do it like literally just whenever I can or whenever I get a chance. And sometimes if I am like at work, it just,
Because when I'm looking at this, I'm gonna tell you what this tells me, young man. That you're not taking this seriously.
I really am.
Because, well, but hold it. You have to understand how it looks to it.
I honestly-
Certainly looks to me, because I sent you an order that you had to blow, and then I don't go a month and all of a sudden you just miss.
I understand.
So do you want to go to jail? I mean, because we can just cut to the chase. I can just send you down.
No, Your Honor.
Here with you.
My mom, my dad, and my girlfriend.
Okay, there's dad back there. Mom, I think I saw them moving to try to get closer. Did you get yourself enrolled in the GED program?
I did, yeah. Classes were starting in January, and then because I just turned 22, and they told I wasn't eligible because I was over the age of 21. So me and my mom are actively looking for a class. She can vouch for me on that, like a free one, because I was enrolled and turned 22.
What?
Because I turned 22, I wasn't eligible. I have the text from them.
So where did you enroll? You enrolled at?
Success Virtual Learning, I believe. It was online.
Oh, okay. And so then they said, once you hit the age of majority, you're not eligible.
Yeah, because I enrolled right before my birthday, because my birthday was December 23rd. And so once I turned 22, I wasn't like eligible to do the GED class anymore, because it was like a 21 age limit, I guess, that they had. But I am actively looking for.
Sometimes you don't take what you've got to do in life seriously, do you?
Sometimes I will admit, no. But this, I promise you, I was truly trying my best. I have not consumed any alcohol. Like when the warrant was issued, I like asked if they could send me in for like a blood test or like whatever to like show that I haven't consumed.
Okay, but here's what you need to understand. It's not I'm worried about your consuming alcohol, because you have to understand you were a 0.223 and were able to operate a motor vehicle, which leads me to believe you were drinking quite a bit. And sometimes it's hard for people just to stop. But what I'm talking about is the missing of blows. Just, I can't understand that. I get every once in a while something happens, and that's typically what that order was designed for. When I saw this one, we sent it, but I said, I hope he gets himself in the right place so that I don't have to send it. And expecting, quite frankly, after I sent out the order, that this is not what I would be dealing. You need to understand that when somebody misses a blow and I put you on a sober link and you miss a blow, I can consider that a positive test. You get that?
I understand.
When I'm talking about taking things seriously, you're telling me you're taking this seriously, but the whole discussion we had about you and graduating and all of that, and me listening to your parents, you got to take more of this seriously and understand you got to do what you got to do. You hear me?
I understand. Yes, I agree.
Mom, you want him back?
Absolutely, and I mean, as far as the missing, you know, he doesn't have a license, he can't drive himself to work. Some of his friends are only able to pick him up at 4 o'clock in the morning. I work from 5:30 till, so life is a little difficult with the rides, it's getting worked out. He is telling the truth, he did turn 22 on the 23rd.
No, I believe him.
We are looking for a program where
I got it.
his father can help out with getting him back and forth. What his girlfriend's willing to help out, I'm willing to help out.
Dad, you want him back? Yeah. Listen, probably should ask the girlfriend. You want him back? Because if you don't want him back, if you tell me no, then I'll put him away. You do? He had to breathe hard because he didn't know what she was going to say. Look, young man, I know you're trying, but you got all these people supporting you. They're all here. There is not a reason for you to fail on this stuff. And the stuff you're messing up on, it's the easy stuff, right?
Yeah.
I'm gonna say it again. You are 0.223. I am just fortunate that I get to yell at you. Because at that level, you could have killed yourself.
He can actually tell you that he lost his brother-in-law for the same blood alcohol content. I don't feel like last year, a year ago.
Brother-in-law, you lost somebody? So you really know how lucky you are, right? All right, so young man, let's do this. Let's just try to start again. I'm not gonna lock you up. Okay? Let's just sort of reset this. Let's try to get you back on track. You're 22. Let's just get you back on track and let you try to do some great things in this world. How about that?
Thank you, Your Honor.
All right, so what I'm gonna do, I'm gonna adjourn your case to the 4th, February 4th, 2026. I want to see some progress in terms of get yourself an NG, okay? And what I'm going to order, we'll do an order now. I'm going to order that you report over to the Department of Community Corrections. Best to do it before you leave here. You have your sober link with you?
Yeah.
Okay. So you have to turn that in. I'm going to put you on the scram tether. I'm going to give you a shot. And I'm going to tell you right now, most people with this blood alcohol level that don't comply with sober link, I don't even trust them on a scram.
Thank you, Your Honor.
And I usually just lock them up and that's it. I'm gonna give you a shot.
Thank you.
You gonna let me down?
No,
You better not.
I will not.
You know how I am. I get cranky.
You
Right?
have my word. Thank you very much.
You're welcome. All right, we'll see you on the 4th.
All right.
Thank you folks for coming down and supporting him.
Thank you, sir.
You're welcome. And young man, I mean it. Give your girlfriend a hug, because if she had said no, you would have been gone. All right? Take care, guys. Young lady? No, come here. Come here. Oh, boy. Get her, Mr. Allen. Court calls the case People versus Latricia Mopkin.
Hannah Mackey on behalf of Mrs. Mopkin, who's approaching.
No, look this way, ma'am. Come on up. Your name?
Latricia Mofke.
Thank you.
Your Honor, requesting to set this matter for preliminary examination. May I address bond, Your Honor?
You may.
Ms. Latricia, she works at U of M as a housekeeper. Currently, she's on non-paid leave. However, that's temporary and she could permanently lose her job there. She has 4 kids and one of them, Ms. Latricia is the sole provider for her kids. Her family is here today in court as well, and she has a place to stay with them upon release. So we're asking for Ms. Latricia to be released, and she is okay with complying with GPS tether or any other conditions the court finds necessary.
Response.
Your Honor, at this point, I'm gonna object. This is an extremely serious case in which the victim was attacked with a hammer in which she was hit in the head several times with that hammer. There was a struggle then for that hammer, and during that struggle, he was then stabbed in his stomach. So given the severity of this case and the injuries that she sustained, I'm gonna object at this point to any modification of bond.
And Your Honor, we are presenting this case as a self-defense, and Ms. Latricia would not be staying at that address upon release. She would be staying with her daughters, looking after her.
I mean, typically the self-defense isn't, I mean, are you indicating that the alleged victim possessed some weapon at some point?
I believe there was some form of altercation.
Well, an altercation is one thing. Are you saying that a weapon was possessed? Because
No.
that might factor into the court's decision, but if that's not what's being said, then I'm not sure that true self-defense is going to apply in any event, although I'm not trying to make that analysis.
There was no actual weapon.
Do this. There's the allegation that there are 2 weapons that would be used by this defendant.
He did have a knife, Your Honor.
Okay, then you can certainly address that even, while I'll factor that in, I still don't think bond would be appropriate or reduction in bond would be appropriate in this case. I'm going to deny your request. Certainly you may raise that after the preliminary examination on the 20th before it gets fresh out.
Thank you, Your Honor.
Thank you. Guys want to walk around? Young lady? No, come here. Come here. Oh, boy. Get her, Mr. Allen. Who is that?
She said.
Who was that?
Family of the last client, I believe, Your Honor. To the full moon.
What?
To the full moon.
No, people are usually better. They're not back yet. There's a problem. You got a problem probably in the hallway, guys. I'm sure security sees it. Can you just call and make sure that they're how many more do I have? This is it.
So, trustee in custody. 2, 5, 6, 7. And you got that over there.
Be careful.
I want to. Oh,
Should have given bond.
yes, I'm so sorry. Yes, so that matter has come back. So I looked up GIS from yesterday, see if comes up this call. We don't know. It's on next week. So.
Right, I'm gonna just step off. If she brings him in, just throw her in the box over here or cup her, put her wherever. Hey, lady, what's your name?
Sequoia Jones.
What?
Sequoia Jones.
Why were you causing a disruption in the court and then
I
didn't
was
come
talking to
back?
my mom's lawyer and he stood up. I wasn't talking to him. I didn't say nothing to him. I was talking.
Why didn't you then stop when I told you to stop?
I apologize.
That doesn't work that way.
Your Honor,
You want to be represented by counsel, ma'am, because you disrupted these entire proceedings. You want an attorney?
Yeah.
The PD can handle this, I think. She can go back into custody. I'm gonna take a brief recess and then I'll bring her back out. We'll deal with it.
All right.
Guess in reference to this case, we'll call it in regard to the Mopkin matter. The defendant does not need to be present and is not present. I think Joy was.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of the respondent, defendant. I don't.
Yeah, yes, she would be responding. Your name, ma'am?
Sequoia Jones.
Ma'am, you know why I held you?
Yes.
Tell me what your thought is on why I did.
Because I disrupted your courtroom.
Yeah, you disrupted the courtroom, and then when I asked you to come back, try to figure out what was going on with you, you just kept continuing to walk. Why'd you do that?
My mind was like blank. That's my first time seeing my mom since, and it was just like a lot. It was a little too much. It was my first time seeing my mom since this incident happened. And I was trying to ask the lawyer something. I was so focused on her answering my question. I couldn't even really like hear anything else. I was too upset. But I'm not using that as an excuse. I take accountability. I was wrong for that. But
Your mom's coming back in a week or two, right?
That's correct, Your Honor.
Huh?
That's correct, Your Honor.
So is it that you can't, in seeing all of that, can't keep yourself composed in the courtroom?
no, I thought it was an understanding before my mom got up here about mentioning her injuries, and nothing was mentioned about that.
Okay.
And that's what I was asking
Can I
her.
just say this?
Oh, okay.
You need to let the attorneys do their job. Okay?
Mhm.
You have an issue to the extent that they'll even talk to you. If you have an issue with that, then you deal with that outside of this courtroom. So should I banish you from coming into this courtroom again?
No,
You think you can conduct yourself?
yeah, yes,
Young lady, I'm gonna give you another chance. If you come back in here and act the way you did, I'm gonna guarantee you this. You'll be locked up like you are now, but I'm not letting you out. Are we clear?
yeah. I have no problem with that. I'm not a disrespectful person.
You're not what?
I said I have no problem with that. I'm not a disrespectful person. I wasn't
Oh,
raised
you
that way.
were today.
I was today, but I'm not.
Not only to
every day.
whoever you were talking to, but also to me, and I hadn't done anything to you. Right?
Mhm.
So just check yourself next time before you come in here. All right, we can release it. Let her go.
Thank you.
Thank you. Court is standing in recess, and I guess we'll come back and do our 2:00 block and on.
In this docket, the court granted an attorney's withdrawal after discovering he never spoke to his client and filed a misleading motion, gave a young SoberLink defendant one final chance with a scram tether after family support, denied bond reduction in a serious hammer and stabbing assault case, and briefly held a disruptive family member in contempt before releasing her with a warning. The consistent message: do the basic things right, communicate, comply, and respect the process, or face the consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.